listening to The Liberty Beat, your daily source for liberty news and activist updates. Online at thelibertybeat.com. John Bush here with your Liberty Beat for April 25th, 2013. Gold opened today at $1,426, silver at $23.12, and Bitcoin is trading at $157. Support for the Liberty Beat comes from Capital City Automotive, honest, reliable, and affordable auto repair for vehicles foreign and domestic. Located at 1802 South Congress. By phone at 512-447-2886 and online at capitalcityautooaustin.com. And now the news. According to an inside source, the Houston Police Department has been building intel on an activist community group called the Houston Freethinkers for at least a year now. The source claims that officers have been briefed during training sessions with videos on the Houston Freethinkers in an attempt to demonize the group and treat them as a, quote, violent organization. The source claims the instructor was able to name each of the group leaders and felt the department had great disdain for Houston Freethinkers, along with Peaceful Streets Project Houston. The Washington Post reports that the Obama administration is funding recruiters to recruit senior citizens for the Supplemental Nutrition Program, also known as food stamps. A Florida recruiter named Dilly Nurios says she is required to meet a monthly quota of 150 people, but often exceeds that goal. Nurios travels to various retirement communities telling seniors that it's okay to get assistance and not to be ashamed. She is employed by a local food bank that receives state funding. Increasing food stamp enrollment in Florida alone brings over $6 billion a year in revenue. Just a decade ago, only half of Americans were eligible for SNAP and received benefits. Today, that number is 75%. Massachusetts Executive Office of Health and Human Services has admitted that the alleged bomber, Tamerlan Tsarnaev, his wife, and 3-year-old daughter were all receiving taxpayer benefits. The benefits were cut off in 2012 when the family became ineligible. It's been released that Tsarnaev's parents were also receiving state benefits. This brings the question of whether or not the taxpayers' dollars were used to help fund Tsarnaev's radicalism. The Department of Transitional Assistance was hesitant to report this, but caved after getting continued pressure by the Boston Herald newspaper. Support for the Liberty Beat comes from PureRainUSA.com, chemical and fluoride-free bottled water available at Whole Foods and Central Market, and by Central Texas Gunworks, self-defense training, CHL courses, and firearm sales. Online at CentralTexasGunworks.com. This is the Liberty Beat for April 25th, 2013.
You gonna do? Yeah. Bad boys, what you gonna do? What you gonna do when they come for you? Bad boys, what you gonna do? What you gonna do when they come for you? When you were 8 and you had bad traits, you go to school and learn the golden rule. So why are you acting like a bloody fool? If you get hot, then you must get cool. Bad boys, what you gonna do? What you gonna do when they come for you? Bad boys, what you gonna do? What you gonna do?
All right, bad boys, what are you going to do when we come for you? Here on the Rule of Law. It is Thursday, April 25th, 2013, and I am one of your hosts, Deborah Stevens, and I am here with my co-host, Randy Kelton. And tonight, we are going to open up the show by railing on some corrupt district attorneys. And apparently, Randy, two district attorneys, or one of them is a former district attorney, but still, 2 district attorneys have bit the dust within a week as far as their career is concerned. We have Rosemary Lehmburg, who is a district attorney of Travis County. She gets busted for DUI, and Randy's going to read a little bit about that. I've seen a few articles on that. And now we have Ken Anderson, a judge in Williamson County, And Ken Anderson was district attorney for 16 years in Williamson County before he became a judge up there. And he has been investigated by a court of inquiry, and there are findings. He was arrested, and I was looking over this document, the findings of fact and conclusion at law that this court of inquiry released on April 19th concerning Mr. Ken Anderson and some of the things that he did when he was district attorney. He basically, and big surprise, Randy, pulled some very nasty moves to get an innocent man convicted of murder of his wife. All right, the poor man is in extreme grief. His wife was murdered by somebody else, not him, and then Ken Anderson goes after him and lies and withholds exculpatory evidence to get this guy convicted. And I don't remember exactly what year that happened, but DNA evidence exonerated the man, and his name was Morton. DNA evidence exonerated Morton, and he was released from prison in 2011. But I'm just going to cut to the chase here, and then we're going to start talking, about the details. The summary and conclusion of the Court of Inquiry on Ken Anderson says that, here it is, summary and conclusion. In light of the foregoing and by way of summary, this court concludes that probable cause exists to believe that number one, Mr. Ken Anderson committed the offense of criminal contempt of court by failing to comply with Judge Lott's order to produce Sergeant Wood's complete set of reports and notes. This is the complete Wood report for in-camera review. And number two, Mr. Ken Anderson committed the offense of tampering with or fabricating physical evidence by failing to turn over to Judge Lott the complete Wood report in order to keep those materials from Mr. Morton's defense and thereby impair the material's availability as evidence. And number three, Mr. Ken Anderson committed the offense of tampering with government records by failing to produce to Judge Lott the complete Wood report, signed and entered this 19th day of April 2013. And this was Judge Stearns that signed this. And this is a 15-page report, 15-page document, findings of fact and conclusion at law by this Court of Inquiry in the 26th Judicial District Court of Williamson County, Texas. I'll give you all the cause number. It's 12-0420-K26. That's 12-0420-K26. And as far as I can tell, none of these three charges are felonies. But this is still pretty major. I mean, I would like to see some official oppression. I would like to see some felony charges come down. But at any rate, he was arrested on these charges, and so we're going to wait and see what happens next. And I've read several articles about it. We're going to go over some of the details. But just as a side comment, it's like the Austin American-Statesman. I mean, it's just... Their article is useless. It really is total uselessness because they don't even tell you what the charges are, for one thing. And then at the end, they try to make it sound like, oh, he's not really in all that much trouble. He said, the article says, this is at the end of the article, according to the Texas Supreme Court's rules on removal of judges, Anderson will be able to continue in office. The State Commission on Judicial Conduct can suspend a judge only after felony indictment from a grand jury or if there is a misdemeanor charge involving official misconduct, the rules say. Oh, is that a fact? Well, I think that there's other ways to get this guy out of office.
I got news for him. Tampering with a government document by a public official goes to a official misconduct.
Yes, I was going to say it does go to official misconduct, and why the court of inquiry did not find that he was guilty of official, that there was probable cause that he committed official misconduct. I have no idea. I guess they're still just trying to protect the guy.
No, official misconduct was a lesser charge. If they had charged him with the crime of official misconduct, it was a lesser included charge. They charged him with the most serious. If they charged him with official misconduct as well as tampering and these others, that would have been stacking.
Yeah, but the thing is, if they charged him with official misconduct, even though it's a lesser charge, then according to the state rules of judicial conduct, that would enable the commission to suspend him. But there's other ways to get him out.
It's not statutory. It's in the case law. If he committed these acts while acting under the color of his official authority, that's official misconduct.
Oh, I know.
He doesn't have to be charged with it. But that's sufficient to remove him from office. So he's still subject to removal.
Oh, yes, absolutely. He's absolutely still subject to removal. That's what I'm saying. This Austin American Statesman article is quite misleading. But at any rate, I think that this is good news. I think that they could have hit him with a lot more. And you never know. A grand jury may hit him with a lot more. Now, here's another thing in this article, this Austin American Statesman article. And I'm just cocking my head and going, huh? You know, because it says that the Williamson County District Attorney Jana Duty is wanting the Attorney General to prosecute this. Now, I don't really quite understand that. I need to go back and look at the statute again, but I didn't think the Attorney General could prosecute except for child support cases.
Hold on. Yes, he can.
Okay, good.
In 2007, new law went into effect, 39.015. 39.01 is official misconduct. 39.015 says that in the matter of an accusation against a public official, the Attorney General has concurrent jurisdiction with the prosecuting attorney. So that is exactly appropriate. And this new prosecutor did exactly what she should have done. If there is one prosecutor on her staff that was on the staff of Anderson, then her whole staff is disqualified.
Yes, there are. It does say that 3 of her prosecutors are assigned to Anderson's court. That is true.
So, no, if they worked for Anderson as a prosecutor at the time this occurred, and now they work for the current prosecuting attorney, the prosecuting attorney's office is disqualified. She would either have to petition for an attorney pro tem to stand in her place, or, which was more appropriate and in statute, she could go to the Attorney General and ask him to prosecute it.
Well, I think, what she's saying here is that she wants the Attorney General to prosecute because she's saying there's a conflict of interest because 3 of her prosecutors are assigned to Anderson's court right now. That's why she wants the Attorney General to prosecute.
That's good enough. And it is exactly appropriate of her. So this means that it tells me that they're going to use this guy as a sacrificial lamb to keep everybody else out of trouble, probably.
Well, all I got to say is that it's about time that these rogues start getting in some trouble, especially with Williamson County, because, I am sure there are thousands, tens of thousands, maybe even hundreds of thousands of people that were wrongfully imprisoned and convicted because of the shenanigans of this guy, Ken Anderson, when he was district attorney. I think he was instrumental in fomenting the outrageous corruption in Williamson County that has caused Williamson County to become notorious nationwide. Randy, like you're always saying, pretty much everybody says, oh, my county's the most corrupt county. in the state. Well, that's not what people say in Texas, for the most part. People in Texas say, no, my county's not the most corrupt county. Williamson County is the most corrupt. I mean, Williamson County is notorious nationwide from coast to coast. People, in fact, I know a lot of people that go up and down I-35. They will detour 45 minutes. They'll add 45 minutes to their trip from Austin to Dallas because they refuse to go through Williamson County, period. Not even on the highway. That's how bad it is.
There's a little more to this. Something I noticed in there, that it was the Supreme Court that invoked the Court of Inquiry. Problem: the Supreme Court has no such power.
Uh-oh.
It's real clear in the code that a district judge must petition the head administrative judge of the district for a court of inquiry. Doesn't say anything about the Supreme Court.
So does that mean that these findings by this court of inquiry are basically moot because or have no effect or can't carry any weight in law because they were improperly impaneled?
That is a real good question. It's similar to the question about Tom DeLay. He was prosecuted and nobody ever filed a criminal complaint against Tom DeLay. And when I raised that in his trial, they threw me out of the building, or out of the courtroom. So they do illegal stuff all the time. And so maybe Mr. Anderson will get his garbage visited back on him. Sounds like just desserts to me. This is Randy Kelton and Deborah Stevens, Rule of Law Radio. I'd like to talk about our Travis County District Attorney when we come back, and then we'll start going to callers. Paul, Ramon, I see you there. We'll be right back.
Thought that I was doing well, but the truth to you I'll tell. MSGs and GMO really ain't the way to go. There's a better way I've seen. It's called tangy tangerine, and we're all drinking tangy tangerine, tangy tangerine, tangy tangerine. We're all drinking tangy tangerine, tangy tangerine, tangy tangerine.
Order Beyond Tangy Tangerine and other great longevity products at LogosRadioNetwork.com by clicking on the Tangy Tangerine banner. Sign up as a preferred customer for wholesale prices or become a distributor and support LogosRadioNetwork.com. So what do you say, Elvis?
Thank you very much.
Are you being harassed by debt collectors with phone calls, letters, or even lawsuits? Stop debt collectors now with the Michael Mirris proven method. Michael Mirris has won 6 cases in federal court against debt collectors, and now you can win too. You'll get step-by-step instructions in plain English on how to win in court using federal civil rights statutes, what to do when contacted by phone, mail, or court summons, how to answer letters and phone calls, how to get debt collectors out of your credit report, how to turn the financial tables on them and make them pay you to go away. The Michael Mirris proven method is the solution for how to stop debt collectors. Personal consultation is available as well. For more information, please visit ruleoflawradio.com and click on the blue Michael Mirris banner or email michaelmirris@yahoo.com. That's ruleoflawradio.com or email michaelmirras@yahoo.com to learn how to stop debt collectors now.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
Look what we got. We asked the question. I wonder what they're hiding. Don't have the answer. Open up, we asked the question. Look what we got. slip and slide.
Them a talk about issues, pussy lord, how they want we to take it easy. Them a talk we too politically and them getting mad and angry. But them not standing up and fight.
Okay, we are back. We are discussing the charges against former District Attorney Ken Anderson of Williamson County, Texas, notoriously possibly the most corrupt county in the nation. There have been documentaries made for over 30 years of just incredible corruption and abuse by the system in Williamson County. At any rate, we're talking about how to get this guy out of office. And I wanted to go back to these charges and the official misconduct. And yes, the three charges that they have in the court of inquiry, that definitely goes to official misconduct. But they didn't include that charge, and it is a lesser charge than the other ones. But what I was commenting on is concerning the State Commission on Judicial Conduct. I'm speculating here that perhaps the reason that the Court of Inquiry did not include that lesser charge is because that would give the State Commission on Judicial Conduct a way to remove him. And even if that's the case, even if the Court of Inquiry was trying to protect him, that it's not much of a protection because there's still plenty of ways to get this guy out of here, and that charge may come down. I mean, there may be a grand jury indictment with some felony indictments after this. This is just the beginning. We'll see what they do to him if they try to protect him or not, how much they will try to protect him. But Randy, you were going to talk about quo warranto removal. I think Randy's got a loud truck passing by. Randy, are you there?
Yeah. Sorry about that. I didn't want to.
Yeah. Okay. Okay. Go ahead. Go ahead with a
okay.
Quo warranto removal.
Yeah, I'm going to it in the. I had the wrong case, but quo warranto is in the Practice and Remedies Code. Give me just a second. Let me look it back up. But if a public official violates the law, I'm sorry. Let me pull the thing up. Give me just a second.
Well, okay.
Here.
Now, Randy,
Yeah,
let me ask you. I mean, this looks like he could be charged with a lot more too. I mean, what about official oppression?
Official oppression, certainly. But the charges they made, tampering with the government document and such, they were more right dead on point. Here it is. Let me give you Practice and Remedies Code, Extraordinary Remedies, Quo Warranto. An action in the nature of quo warranto is available if a person usurps, intrudes into, or unlawfully holds or executes a franchise or an office, including an office in the corporation created by an authority of the state. A public officer does an act or allows an act that by law causes a forfeiture of his office. And I'll have to find it again, but if a public official violates a law relating to his office, he's subject to quo warranto removal. And a public official, anytime a public official is accused of violating a law relating to his office, that is subject to indictment under 2.03 Code of Criminal Procedure. This is the very thing that we keep going after these prosecutors for, and Anderson's one of them, for exactly this issue, for filing complaints with him and he refuses to act on them. That's a violation of his office, just like what he's been charged with. And if what they're saying is, and what he's probably going to win on, is statute of limitations. The statute of limitations have ran. So what I'm looking to do is, you guys remember when I spent the night in Williamson County Jail? I intend to go and file again with him, and I want to look at filing in this court of inquiry accusations that he violated Article 2.03 more recently for the purpose of shielding an officer from prosecution by refusing to take a criminal complaint and then accusing him of calling these local police officers and having them beat me up and throw me in jail as an attempt to tamper with a witness and obstruct justice. Maybe we can get him on one of those.
Okay, well, Randy, let me ask you something. The statute of limitations thing, this doesn't make much sense to me because if, say this, I don't know when this happened, when this murder trial was. All right, I haven't been able to find that out yet. I just started researching this earlier today. But so let's just say, for example, it was 15 years ago, all right, and the statute of limitations is 2 years or whatever. Well, if the evidence is just now coming out of what this guy did, then how can they claim statute of limitations as a defense? I mean, does that just mean that people can just go around committing crimes, and as long as it's not discovered with evidence of the crime is not discovered within the statute of limitation period, that means they can't be prosecuted? I mean, what? I don't quite understand. Exactly. I don't quite understand what's going on here.
That's exactly what it means.
Oh, that's not right. Okay.
That's exactly what it means.
That is not right. Okay. I am in total disagreement with that.
This would require a statutory amendment.
Well, see, look, for fraud, we're always talking about with fraud charges, the statute of limitations, the clock starts to tick when the fraud is discovered. It's the same sort of thing.
Well, that's what I was thinking about. How do we get to fraud? Because fraud was one that the statute of limitations will only start ticking when they did that DNA test. And this would go to fraud. So we may want to go back and petition a grand jury to indict him for fraud. Since we have the determination of probable cause by a court of inquiry, that would be sufficient to give a grand jury reason to believe that he committed these acts. And if we can show that the acts constitute fraud, then we can still go for him for that. And it may well be that these guys charged him with what they did because they knew he would have this defense.
Yes, that's what I'm saying. It still looks like they're just trying to protect him. They not indict, but they charge him with crimes that the statute of limitations is run, and that is a horrible provision in the statute because he ruined this guy's life. Okay? I mean, it seems like there should be some justice here.
The statute of limitations was put in so that if someone accused you of doing something 20 years ago, some minor offense, it'd be absolutely impossible to prove up. You could still be arrested and held and forced to stand trial. And they put in this statute of limitations that said you cannot hold something over somebody's head for the rest of his life. That would put people open to any kind of cockamamie complaints from back in history that could not be proven or disproven, and put people subject to arrest for anything anybody wanted to accuse you of.
Well, okay, that's fair. That's reasonable, but we've got to figure out where to draw the line here because
that's easy.
Ken Anderson ruined this guy's life. He put him in jail, and he was an innocent man.
Exactly. What we need is an amendment to the statute that would toll the statute of limitations so long as the harm created by the crime was still in effect. So the person who was wrongfully convicted was still being harmed every day he was in jail. The statute of limitations should toll until that time.
Yeah. You mean it should the clock shouldn't start ticking as long as the harm is still being done, you mean?
Exactly, as long as the guy's still sitting in jail.
Yeah. All right, well, we'll be right back, folks. This is the rule of law.
Russian writer Alexander Solzhenitsyn was sentenced to 8 years hard labor for criticizing Stalin in a letter to a friend. Good thing those days are past, or are they? I'm Dr. Catherine Albrecht. More in a moment.
Google is watching you, recording everything you've ever searched for and creating a massive database of your personal information. That's creepy, but it doesn't have to be that way. Startpage.com is the world's most private search engine. Startpage.com doesn't store your IP address, make a record of your searches, or use tracking cookies, and they're third-party certified. If you don't like Big Brother spying on you, start over with Startpage. Great search results and total privacy. Startpage.com, the world's most private search engine.
Back in the bad old Soviet days, officials routinely opened people's letters and scanned them for political correctness. Today, the government of Finland is opening and scanning people's letters for a different reason, to deliver their mail electronically. Hundreds of Finnish citizens are letting postal workers open their mail and scan each letter and bill into a computer file they can see online or receive by email. They hope the idea eventually goes viral. Postal officials promise the staff is sworn to secrecy and would never read the contents of the letters. Somehow, if he were alive today, I doubt Alexander Solzhenitsyn would be among the first to sign up. I'm Dr. Catherine Albrecht. More news and information at CatherineAlbrecht.com.
This is Building 7, a 47-story skyscraper that fell on the afternoon of September 11th.
The government says that fire brought it down. However, 1,500 architects and engineers concluded it was a controlled demolition.
Over 6,000 of my fellow service members have given their lives.
And thousands of my fellow first responders are dying.
I'm not a conspiracy theorist.
I'm a structural engineer.
I'm a New York City correction officer.
I'm an Air Force pilot.
I'm a father who lost his son.
We're Americans, and we deserve the truth.
Go to rememberbuilding7.org today.
It is so enlightening to listen to 90.1 FM, but finding things on the internet isn't so easy, and neither is finding like-minded people to share it with.
Oh, well, I guess you haven't heard of Brave New Books then.
Brave New Books?
Yes, Brave New Books has all the books and DVDs you're looking for by authors like Alex Jones, Ron Paul, and G. Edward Griffin. They even stock Interfood, Berkey products, and Calvin soaps.
There's no way a place like that exists.
Go check it out for yourself. It's downtown at 1904 Guadalupe Street, just south of UT.
By UT, there's never anywhere to park down there.
Actually, they now offer a free hour of parking for paying customers at the 500 MLK parking facility, just behind the bookstore.
It does exist, but when are they open?
Monday through Saturday, 11 a.m. to 9 p.m. and 1 to 6 p.m. on Sundays. So give them a call at 512-480-2503 or check out their events page at bravenewbookstore.com.
Live Free Speech Radio, LogosRadioNetwork.com.
Mr. Officer, you're taking the law in the hand. Won't you follow the law of the land? I don't understand. Your job is to protect and to serve, not beat and abuse. Officer, when you gonna stop abuse your power? 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 So please, Mr. Macklin, teach officers not to abuse their power. Send a request to the leader, the captain of all officers. Tell them to uphold the law, and please don't abuse their power. The beat and the beat and the cheat and the cheat and the lie.
All right, we are back. When are you going to stop abusing the power? And they're not going to do it, Randy. They're not going to stop until we make them stop with things like courts of inquiry and indictments and prosecutions and lawsuits. And before the break, we were talking about this statute of limitations problem. This seems to be kind of severe. And I guess when the lawmakers put in those statute of limitations, obviously it's a good reason so that people can't just hold stuff over your head for the rest of your life or make things up and, make up a story that you did something 30 years ago and then you have to be arrested and all this stuff. I mean, it's legitimate reasoning, but I guess they just didn't consider something like this, like a white-collar crime, so to speak, white-collar government crime that is not discovered until after the statute of limitations has run out, and it ruins somebody's life, okay? That people getting put in jail for no reason, for murder. I mean, we've got to start petitioning our lawmakers that when they make these laws, that they've got to take into consideration the what-ifs when it comes to government servants, okay, public servants committing certain types of crimes like this. So, I don't know. There needs to... I like your suggested change, Randy, about that the statute of limitations doesn't start to tick as long as there's still damage that's occurring. I like that. That's a good amendment there.
There may be another way to get at this.
Yeah, I was going to ask about the fraud.
Unlawful restraint. A person commits an offense if he intentionally or knowingly restrains another person. It is an affirmative defense to prosecution under this section that the person restrained was a child, that the actor was a relative, that the actor's sole intent was to assume lawful control of the child. The person restrained was a child. The actor recklessly exposes a victim to substantial risk of serious bodily injury to which he blocking. It is no offense to detain or move another under this section when it is for the purpose of effecting a lawful arrest or detaining an individual lawfully arrested.
Aha. But what's the statute of limitations on that one?
Didn't say exactly what I wanted it to. If he commits an offense, if he intentionally and knowingly restrains another person, the prosecuting attorney intentionally and knowingly restrained this person when he had reason to believe that the person was not guilty of the act. That's a stretch, but since the person is still being restrained, or still was until recently, that would toll the statute of limitations.
Oh, I see what you're saying. Yeah, and he was released in 2011, and so probably it's still within the statute of limitations period.
I think it's 3 years on official oppression. This one doesn't have. This is a Class B misdemeanor, and I have to look at a Class A.
All right. Well, let me ask you something else, Randy, about these charges. I think they're pretty much all of them are misdemeanors. Now, it's my understanding that still all of this would have to go before a grand jury, but they just don't do it that way. They don't bring things before a grand jury unless it's a felony. Is there some way that we can press the envelope to have these charges go before a grand jury, to have them actually indicted on these misdemeanors? Because if we can get them indicted, then we can do the quo warranto removal.
Yes, yeah, we can do that. I have some, I don't know, what year was I thrown in jail in Williamson County?
I don't remember.
I think it was about 3 years ago. I know my limitations has ran on suing them. Too busy helping other people and didn't do my own.
Yep.
Well, we can find lots of. I think we've had a number of people file criminal charges against public officials in Williamson County. So we get any one of them where the prosecutor failed to present the complaints to the grand jury. That's dead bang.
Okay, so you're saying have somebody actually file a criminal complaint with the district attorney in Williamson County to try to make that person give it to a grand jury, and they're not going to do it?
Yeah, well, under Article 2.03,
yeah.
If a prosecuting attorney is made known that a public official has violated a law relating to his office, he shall reduce complaint from information submitted to the grand jury. He has no discretion in that matter.
Right, but the prosecutor doesn't want anything to do with this. He's or she is asking for the attorney general to handle it.
That's a different issue.
Okay.
If somebody has went to the previous prosecutor and filed a complaint against the previous prosecutor, the law doesn't say that a prosecuting attorney who is not disqualified. It says a prosecuting attorney.
Yeah, and she's not disqualified anyway. She's just saying that she believes there's a conflict of interest and she doesn't want to handle it.
Right. See, now that she can still do that afterward, but when you give her the complaint, her duty is invoked, and that would be a good complaint to give to the current prosecutor. The previous prosecutor is being hammered, so you go to this prosecutor with a criminal complaint accusing the other prosecutor of not acting properly on a criminal complaint like the one she just got.
Well, Randy, let me ask you this. He's already been arrested, so it seems to me that somebody must have filed a complaint, or did they arrest him just based on the findings of fact and conclusion at law from the court of inquiry? I mean, is that even lawful? I mean, doesn't there have to be a complaint filed?
Well, there should be a complaint filed.
Okay, but if there's not a complaint filed, then does that mean that the arrest was unlawful?
I'm going to bet there is, because the Freedom Project, or whatever it's called, petition, they instituted this petition. They filed a petition asking for a court of inquiry, and that would have almost certainly had criminal accusations in it.
Well, then there's already been a complaint filed, most likely. So then that means that this district attorney is already breaking the law by not reducing the information to a complaint and giving it to grand jury.
Well, the district attorney didn't get it. The court of inquiry got it. And then the court of inquiry is like an examining trial.
Okay.
They issue a finding, and then they will issue a warrant. I'm sure the court of inquiry issues a warrant, and then they will forward the complaint to the prosecuting attorney, and he's to give it to the grand jury.
Yeah, okay. Well, that probably has already happened. I mean, as far as the complaint has probably already been forwarded to this lady prosecutor who's like, I don't want to do anything with this.
Yeah, since the court of inquiry was essentially the same as an
examining trial.
It's an examining trial. Then Chapter 16 and 17 would apply. Okay. Chapter 16 tells them how they'll hold the hearing and how you protect all the accused rights. Chapter 17 and 17.30 would order the magistrate, or whoever the head of the court was, to seal all documents had in the hearing, cause his name to be written across the seal of the envelope, and forward it to the clerk of the court of jurisdiction, which would be, in this case, even though it's a misdemeanor, would be the district court, since it's a complaint against a public official. And then the prosecuting attorney would then be required to reduce the complaint from information, submit it to the grand jury.
Okay, well then, so maybe we need to go after this current prosecutor so that we can get an indictment here, because the whole point of wanting to get an indictment is so that we can do the quo warranto removal, because he's probably going to get out of these charges because of the statute of limitations unless there's any way to bring in fraud. And we're not sure if that's possible, so we may... this is the only way we're going to get this guy out of here is with quo warranto. So we have to get an indictment. All right, folks, we are coming up onto a break. When we get back, we're going to talk about Rosemary Lehmburg. This is The Rule of Law.
Mr. President, members of Congress, you've been making a lot of noise about taking our guns away. But you might want to review history. 1835, Gonzales, Texas territory. The authorities wanted to confiscate the big gun that protected that colony. You know what the people said? Come and take it. Because they were willing to fight for their freedom and their guns. So are we.
Come and take it if you want it. Come and take it if you think you can. Come and take it, but I warn you, you'll have to pry it from my cold dead hands. We want the freedom that God gave us, so you best not cross that line. If you want this gun, you gotta come through us and take it.
One shot at a time. Just like Gonzalez, we're keeping our guns.
Are you the plaintiff or defendant in a lawsuit? Win your case without an attorney with Jurisdictionary, the affordable, easy-to-understand 4-CD course that will show you how in 24 hours, step by step. If you have a lawyer, know what your lawyer should be doing. If you don't have a lawyer, know what you should do for yourself. Thousands have won with our step-by-step course, and now you can too. Jurisdictionary was created by a licensed attorney with 22 years of case-winning experience. Even if you're not in a lawsuit, you can learn what everyone should understand about the principles and practices that control our American courts. You'll receive our audio classroom, video seminar, tutorials, forms for civil cases, pro se tactics, and much more. Please visit ruleoflawradio.com and click on the banner or call toll-free 866-LAW-EASY. Okay, folks, we are back. We just have a few more comments on this Ken Anderson deal before we start talking about Rosemary Lehmburg, and then we'll go to your calls after that. Randy, the other way that we could get this guy out of here is if we could get him charged with official misconduct, then we could pressure the State Commission on Judicial Conduct to remove him. Now, how could we do that? Could we make that happen just by one of us filing a criminal complaint against him for official misconduct? What? Julius,
he's one of our callers. He has recently filed a set of complaints in Williamson County, and the prosecuting attorney failed to act on those criminal complaints in accordance with Article 2.03 Code of Criminal Procedure. That should be enough. And that accusation is dead bang.
So one of us could do it, is what you're saying?
Yeah, absolutely. We could show that the complaint was filed with the prosecuting attorney, and if he's done it according to our directions, he did it certified mail, return receipt. Therefore, the prosecutor cannot claim he did not receive it. And under 2.03, he was required to reduce it to an information submitted to the grand jury. We can check the minutes of the grand jury. If we don't find evidence of a true bill or no bill, that's prima facie evidence that he did not perform his duty. That's sufficient to indict.
Well, let me ask you this. I mean, if one of us files a criminal complaint against Ken Anderson for official misconduct, say with the district attorney's office or whatever, is that in and of itself enough to go to the State Commission on Judicial Conduct and say, look, there's charges that have been filed against this guy for official misconduct? Or no. Does there actually have to be? No,
that'd go to the bar, but no. And it shouldn't be that way.
Yeah, I know.
Otherwise, anybody could make any accusation against any public official and have him snatched out of office. However, once he is indicted, that's not just anybody. That's a grand jury of our peers has stated that there is sufficient evidence to believe a crime has been committed and that this person committed it. That is enough for warrant or removal.
Right.
So we filed with the current prosecuting attorney, accusing the previous prosecuting attorney of not taking a complaint just like this and giving it to the grand jury the way he's required to. And let's see how the current prosecutor dances with that one.
Yeah, really. All right. Well, very good. Okay, so I think this is a pretty in-depth analysis here of this Ken Anderson case. All right, now we're going to talk about the other prosecutor, the other district attorney here in Texas. This one, Travis County District Attorney, that has also bitten the dust, politically speaking, career-wise, it would seem, with this DUI thing. So, Randy, you had some information you want to talk about that.
Yes, I'd heard some stuff that people were claiming that the prosecutor had been set up for political reasons. Every time anybody does anything, I get this kind of stuff. But in looking at the reports on her arrest, it doesn't look like she was set up at all. Apparently, some people called because someone was driving down a hiking trail or a bike trail in a car erratically and running out into oncoming traffic. And they came down and they found this person who happened to be the district attorney.
Yeah.
Oops.
Yeah.
And
well, I didn't read about the biking trail, but look, this is what it says on KView, a local news website here. It says, according to the arrest warrant, a man saw her driving in the shoulder near Home Depot around 10:45 Friday night. He followed her and then called 911. He says that she swerved in and out of traffic, ran through the Comanche Trail intersection, and then pulled over on her own in front of St. Luke's Church, and that's where the Travis County Deputy Sheriff met up with her.
Yeah, and apparently she kind of tried to throw her weight around and get him to call the sheriff. And apparently they didn't do that. Then they complained that they put a spit mask on her.
What?
And that she had never tried to spit at him. And then they looked at the videos and the jail videos. And when the guy was putting on the mask, he explained to her that was so no one would recognize her. So she don't get to complain about that one.
Yeah.
But she's in this. They give her 45 days, and that's enough for quo warranto removal. And that should go to. They said she absolutely refuses to resign. A drunken driving arrest, Travis County DA apologized, says she'll remain in office. Well, a conviction for drunk driving is okay. That's not an offense related to her office.
No, and it's also a misdemeanor charge, so there's not going to be an indictment on this one either.
But there should be. There's required to be an indictment.
Oh, I know there is.
Official.
I know.
Okay.
I know, but they never do it the way they're supposed to.
We may work on that one, and that's her own office that didn't present it to the grand jury. But then again, this is not an offense related to her office, so that raises a question. However, I do believe this will come up as an act of moral turpitude. And that should be enough to disqualify her from holding office. We'll look at that. If she's refusing to stand down, it would be nice if we could exert enough pressure to get her removed. It is absolutely inappropriate to have a convicted drunk driver standing as our district attorney. That is just unacceptable.
Well, especially the way the drunk driving prosecutions go in Texas. And, Randy, you made an excellent point to the committee, the Judicial Committee in the House, the state legislature, a couple of years ago. We were there speaking out against this ridiculous bill that they want to have sobriety checkpoints and all this nonsense. And they even admit that it's so-called security theater. They admit that it doesn't really do anything to catch drunk drivers. And in fact, it can make the problem worse because people know about the checkpoints and then they just go around them. And it takes cops off the street who could be seeing actual drunk drivers and arresting them. And meanwhile, they're having to run these stupid checkpoints. Anyway, the people speaking in favor of the bill and Mothers Against Drunk Driving and all this, trying to pull on these emotional heartstrings and all of that, getting people feel sorry for them and all of that. We have to do something about drunk driving in Texas, because the problem is getting worse and worse and worse. And so, Randy, you made the point, and you weren't the only one that made the point that the reason that it's such a problem is because you have all these thousands of people that have multiple first-time convictions of drunk driving on their record. Multiple first-time convictions? How does that happen? It happens because the prosecutor deals away the case because they just want to keep people in the system, and have them on probation. They admit it. They admit the whole point is to keep them in the system and make them go to these classes and make them have the breathalyzers installed in the cars because that's big business for these contractors that provide these services and all this and that. And so the prosecutor deals away the case, and so people most of the time just get sort of a slap on the wrist, and they have these multiple first-time convictions, and it doesn't really affect their lives that much other than the fact that it costs thousands and thousands and thousands of dollars to deal with a DUI charge, and so that's why people don't take it seriously, and it just keeps happening, and the problem keeps getting worse because the prosecutor deals away the cases instead of prosecuting people. Okay, so it's absolutely unacceptable to have a prosecutor who's been convicted of DUI for that reason alone. Anyways, I'm sorry, I'm ranting. It's pretty ridiculous.
I had a witness on the stand when a sheriff's deputy tried to kill me and couldn't get it done and then arrested me to cover up what he did. Well, they had a witness. And they put the witness on the stand, and he testified at what he claimed to see. And from where he testified he was at, he couldn't possibly see anything. So the question was, why would he testify to something he didn't see? So I get him, and I said, Mr. Starr, have you ever been arrested? Oh, well, a time or two. A time or two. Well, Mr. Starr, I have your criminal history here. And looking over your criminal history, why, you have been a bad boy. Mr. Starr, have you ever been arrested for drunk driving? Oh, well, yeah, I have. How many times were you arrested for drunk driving? Oh, a time or two. I said, or two, or three maybe. 4, Mr. Starr, maybe 5, 6, 7, 10, Mr. Starr.
Wow.
10 arrests for DUI? Well, yeah, maybe. No more questions.
Yeah, and it doesn't matter what kind of laws the legislature passes to be tough on drunk drivers. It doesn't matter if they want to put up checkpoints or anything else. It doesn't matter if they make the laws say that you go to prison for 30 years for drunk driving. None of it's going to matter if the prosecutors are going to deal away the cases. So that issue has to be addressed. I think there should be some kind of requirement on the prosecutors to limit their ability to deal away these cases. But anyways, we are coming up to the top of the hour break, and we can start taking your calls on the other side. This is the Rule of Law. Folks, if you'd like to call in, 512-646-1984. We will be right back.
The Bible remains the most popular book in the world, yet countless readers are frustrated because they struggle to understand it. Some new translations try to help by simplifying the text, but in the process can compromise the profound meaning of the Scripture. Enter the Recovery Version. First, this new translation is extremely faithful and accurate, but the real story is the more than 9,000 explanatory footnotes. Difficult and profound passages are opened up in a marvelous way, providing an entrance into the riches of the Word beyond which you've ever experienced before. Bibles for America would like to give you a free recovery version simply for the asking. This comprehensive yet compact study Bible is yours just by calling us toll-free at 1-888-551-0102 or by ordering online at freestudybible.com. That's freestudybible.com.
You're listening to the Logos Radio Network at logosradionetwork.com.
You're listening to The Liberty Beat, your daily source for liberty news and activist updates. Online at thelibertybeat.com. John Bush here with your Liberty Beat for April 25th, 2013. Gold opened today at $1,426, silver at $23.12, and Bitcoin is trading at $157. Support for the Liberty Beat comes from Capital City Automotive, honest, reliable, and affordable auto repair for vehicles foreign and domestic. Located at 1802 South Congress. By phone at 512-447-2886 and online at capitalcityautooaustin.com. And now the news. According to an inside source, the Houston Police Department has been building intel on an activist community group called the Houston Freethinkers for at least a year now. The source claims that officers have been briefed during training sessions with videos on the Houston Freethinkers in an attempt to demonize the group and treat them as a, quote, violent organization. The source claims the instructor was able to name each of the group leaders and felt the department had great disdain for Houston Freethinkers, along with Peaceful Streets Project Houston. The Washington Post reports that the Obama administration is funding recruiters to recruit senior citizens for the Supplemental Nutrition Program, also known as food stamps. A Florida recruiter named Dilly Nurios says she is required to meet a monthly quota of 150 people, but often exceeds that goal. Nurios travels to various retirement communities telling seniors that it's okay to get assistance and not to be ashamed. She is employed by a local food bank that receives state funding. Increasing food stamp enrollment in Florida alone brings over $6 billion a year in revenue. Just a decade ago, only half of Americans were eligible for SNAP and received benefits. Today, that number is 75%. Massachusetts Executive Office of Health and Human Services has admitted that the alleged bomber, Tamerlan Tsarnaev, his wife, and 3-year-old daughter were all receiving taxpayer benefits. The benefits were cut off in 2012 when the family became ineligible. It's been released that Tsarnaev's parents were also receiving state benefits. This brings the question of whether or not the taxpayers' dollars were used to help fund Tsarnaev's radicalism. The Department of Transitional Assistance was hesitant to report this, but caved after getting continued pressure by the Boston Herald newspaper. Support for the Liberty Beat comes from PureRainUSA.com, chemical and fluoride-free bottled water available at Whole Foods and Central Market, and by Central Texas Gunworks, self-defense training, CHL courses, and firearm sales, online at CentralTexasGunworks.com. This is the Liberty Beat for April 25th, 2013.
They want to chant down Babylon and burn down the whole nation. But them operate the land wrong. I'm a say Republican and them a scratch man. Tell them I'm a libertarian. Them say we born to lose but we born to win. Come grab one. Justice and peace. Chant love rule this time. And what we say? Chant for our wars.
Okay, we are back, folks. It is Thursday, April the 25th, 2013. We are about to take your calls. But, Randy, I just wanted to make one more comment about these rogue district attorneys before we move on. In relation to Rosemary, the Travis County district attorney, DUI is one thing regarding moral turpitude, but I was going to say, if she had been caught engaging in pedophilia, well, that would have been a major career advancement opportunity for her, because Janet Reno All right. Former Attorney General Janet Reno under the Clinton administration. She was district attorney. She was a state district attorney in Florida before that. And she got caught on the side of the road by a state trooper in Florida, naked with a 13-year-old. Okay. A 13-year-old boy. And I don't know how much trouble she got in over that, but shortly thereafter, Bill Clinton goes, yeah, that's the kind of person I want to be Attorney General of the United States. Bring her on up. Bring her into the White House. So anyway, I just wanted to make that little comment. What do you think about that, Randy? Randy?
That's cold.
It's true.
It's true, but cold.
Okay, so,
it's frightening that it is that obvious and blatant. So we need to get ourselves busy and take advantage of this particular spot in time. The stars seem to be aligning themselves. We've got Williamson County prosecutor going down. We've got Travis County prosecutor getting hammered. We need to start going after these prosecutors and really get their attention. If we can't get the legislators and the judges to do their jobs, maybe we can take care of them politically.
Yep. You
and I do our jobs because the politics seems to be moving in our favor. Now let's go ahead and move to callers.
Yeah, let's go to the callers. We got Paul in Wisconsin. Wow. Yes. Paul?
Hey, Randy.
Hey.
How are you?
Howdy.
I'm here.
Tell me what you got.
Okay. Well, first I got a question about something that's on the court access internet site. Under my case number, it has an order that was 410 of this year that says denying request for issuance of a criminal complaint. Now, these are the complaints I sent in against a couple officers. Now, why would that be on my case file?
Will you speak up just a little bit?
Okay, I'll try to. On the court access internet site, it's got an order for denying requests for issuance of a criminal complaint. Now, these are the complaints I filed on a couple officers involved with the case. I was wondering why that would be on my under my case number on that access.
That is a good question, and it would go directly to Wisconsin law. I can't see they're treating that like some sort of a motion in the court. You need to go back and look at the Wisconsin Criminal Procedure Code. In Texas, there is a set of rules for how complaints are filed and handled. Every state is going to have some rules on how complaints are to be filed and handled. Read what it says. And read it whether it says or not that a judge has the power to deny you in your right to file a criminal complaint. Or I don't even know if that would be considered a right. But even if it's not considered a right, it's not something, unless the judge has been given specific power to take this action, then he's not going to have this power. Because unlike you can do anything you want to. And the public officials, they may only do what the law specifically authorizes them to do. So unless a judge is specifically authorized to forbid a citizen from filing a criminal complaint, you should file against the judge. You've probably got a shielding from prosecution statute, In Texas, it's 38.05 penal code. You'll probably have one in Wisconsin.
Okay.
If you don't have a shielding, you will almost certainly have an obstruction of justice.
Okay, I'll look for him. Also, this judge that did this, I filed a judicial conduct complaint against him. Now, these complaints, I actually sent them into the other circuit court judge, because we only have 2 judges in this county. And
now, wait a minute. Do you have a judicial conduct commission in Wisconsin?
The judicial, commission, yeah.
What is the procedure for filing a judicial conduct complaint in Wisconsin?
Oh, you just fill out the form and send it in.
Did you send it in to the commission?
Yes, I did. Certified mail. Even got the card back.
Okay, good. So you also filed one with a judge?
I filed one on the judge.
I thought you said you filed one in a different court with a different judge.
Oh, no, the complaints, because these criminal complaints, I filed those with the other circuit court judge in the county.
Ah, okay.
But
and what did he do with it?
Judge's lap.
Say that again?
I didn't send him to this judge. I sent him to the other circuit court judge, but somehow they ended up back in this judge's courtroom.
Oh, wonderful. This is good. Now file against this other judge for tampering with a government document, for filing your criminal complaints in your... Was that a criminal case you had or a civil case?
Both. But this is in the criminal case.
Which did he file the documents in?
The criminal.
Okay. I would like see if you can find where he has authority to do that. If you can't find it, then file against him for tampering with a government document. Look and see what the law requires the court to do with the complaint. In Texas, he's to hold an examining trial and then seal the complaint in an envelope with all other documents had in the hearing, cause his name to be written across the seal of the envelope and forward it to the clerk of the court of jurisdiction. There's going to be something similar in Wisconsin law telling the judge after he makes a determination of probable cause what he's to do with the paperwork in order to transfer jurisdiction from the magistrate court to the trial court. And he apparently didn't do that. So file on him for that. This is exactly what we want to happen. Tar baby. He just stuck to it.
Yeah. Okay. Now that's the question I had about that. This other goes back to the attorney I called you about. And
okay.
He's wanting...
Yeah, our callers are picking up, so kind of go quickly.
Okay. Anyways, he filed a motion to withdraw as counsel. All right. Now, he filed this on the 15th, and the 24th says a motion and order for withdrawal of counsel. And that was yesterday. Now, I didn't get any of this stuff. I wasn't even aware of any of this stuff until yesterday, after I got the mail.
Okay, that's good. That's okay. That's cool. Nice going, chump lawyer. Bargreave the lawyer, judicial conduct complaint to judge, sue the lawyer for breach of contract, and the judge for interfering with a private contract.
Okay. Because,
you had a private contract with this lawyer, and that judge had no business interfering with it. No, now, they may have laws that say that the judge can do what he did. We don't care. Because the judge can only do what he did if in doing what he did, he doesn't violate Constitution. And the federal Constitution forbids the interference with private contracts.
Okay.
So filed federally against the judge for interfering with the sue him in the federal court. That'll be a hoot.
Oh, no. I mean, no, this is where it's all going.
Yeah, so this is good. They're not doing what they're supposed to. Great. Now you get to, every time they do that crapola, you get to turn the heat up on them.
Right. Because yesterday I sent out the criminal complaints on those officers and to both the judges. I sent them to the DA this time.
Good.
So we'll see what he wants to do.
Check the law, see what the criminal procedure code tells him he's supposed to do with complaints. And when first misstep, then you file against him. Okay, we really need to move along. We've got a bunch of callers stacking up today.
Okay.
Do you have anything else for us?
Well, yeah, I mean, I was going to ask you, but that's okay, Randy. I'll just give you a call sometime, maybe.
Okay, call in tomorrow. We got a 4-hour show tomorrow, and we used up the first hour today.
Yeah, I know. Okay.
Okay.
Take care.
Thank you, Paul.
Bye.
Okay, now we're going to Mark in Nevada.
Hey, Randy Kelton, how are you?
I am wonderful. I don't care what everybody says.
Yeah, I was listening to that interview you had with Alex Jones in June 18, 2012, and it really got me to thinking, you know. We had found a short sale agent for this house we've been in. Now, let's back up just for a second real fast, Randy Kelton. The house was bought from Republic Mortgage, which was the same agent became a broker, left the company he was with 17 years. We bought a house in 98. So naturally, I wanted to go with someone with experience. In 05, I trusted him. I went to him. Republic Mortgage, I find out later, like in the last month, was an origination company, a front for Countrywide, had a big credit line, all from Countrywide. Anyway, so now I'm offered a series of choices, right? Well,
Mark, can you hold on one moment because we are going to break, and I don't hear Randy either. He may have dropped off, so I need to check on that.
No, somebody.
Oh, there he is. Okay.
Again.
All right, we'll be right back, folks.
Hey, tangy tangerine, see what you've done to me. I'm losing weight and I'm not half the man I used to be. Hey, tangy tangerine, you make me feel so good. I don't eat so much food. Ain't I a sight compared to what I used to be? Calcium, magnesium, selenium, and zinc. Take a moment now and think. If you have a little drink, every day will bring the life that you've been looking for.
Beyond Tangy Tangerine is available at Brave New Books, located at 1904 Guadalupe Street. The bookstore also carries the works of Dr. Joel Wallach, founder of Youngevity and creator of Beyond Tangy Tangerine.
At Capital Coin and Bullion, our mission is to be your preferred shopping destination by delivering excellent customer service and outstanding value at an affordable price. Capital Coin features a great selection of high-quality coins and precious metals. In addition to providing the best prices in the nation, we want to bring you the best shopping experience both in-store and online. In addition to coins and bullion, we carry popular Youngevity products such as Beyond Tangy Tangerine and Pollen Burst. We offer freeze-dried storable foods by Augustin Farms, Berkey Water Products, ammunition at 10% above wholesale, and more. You can lock in a spot price with our silver pool, and we set up metals IRA accounts. Call us at 512-646-6440 for more details. We're located at 7304 Burnett Road, Suite A, about a half mile south of Anderson. We're open Monday through Friday 10 to 6, Saturdays 10 to 2. Visit us at capitalcoinandbullion.com or call 512-646-6440.
This is the Logos Radio Network.
Ain't gonna blind me. Don't bore me. Well, ain't gonna fool me with that same old trick again. I was blindsided, but now I can see your plan. You put the fear in my pockets, took the money from my hand. Ain't gonna fool me with that same old trick again. Ain't gonna fool me.
Okay, we are back. This is the Rule of Law. We're taking your calls. We're talking with Mark in Nevada right now about mortgage issues. And we had another caller on the line that was before Mark. It was Will in Texas that was calling in about DUI issues. And we wanted to take him next, but Will dropped off the line. So, Will, if you're out there still listening, please call back in because we had been talking about DUI issues. So call back in and we will take you next in line whenever you call. All right, so I just wanted to put out that call from Will to call back in. All right, Randy, we're talking with Mark right now. Go ahead, Randy.
Okay, Mark. We need to move kind of quickly. We don't have time to go through the whole story of your entire mortgage.
Yeah.
What is your issue?
Okay, so now I just got the recording from the Clark County Recorder's Office. And I printed out the whole thing. And in it, I see, there's two mortgages. One of them is initialed on every page. The other one's not. Looks like two different.
Okay, hold on. Two mortgages. Are they both copies of the same? Are they deeds of trust? You are in Nevada. Is that a mortgage state or deed of trust state?
It's a deed of trust state.
Okay. Are both of the mortgages the same date?
Are they both the same date?
Yes.
Let's see. One of them.
Is it an 80-20 loan? Did you have...
Yes, 80-20. That's what it was. Yes.
Okay. The second mortgage won't have to be signed on every page. That won't make any difference.
Well, that's the one that's signed on every page. The first is not.
That's not important anyway. Did you sign the document itself?
Yes, I did. Okay. So then there's cross-outs, including the tax ID number, not initialed. I don't know if that was before or after I signed, okay?
Okay, that won't make any real difference if the tax ID number does not go to an adjudicatable issue.
Okay. There's a series of documents there that I don't really understand. They're suspicious signatures. They're notarized in...
Okay, what are the titles on the documents?
Okay, the titles of the documents. All right. Okay, one with very similar substitution of trustee and full reconveyance is a document.
That's an interesting document. Substitution of trustee is one thing. Full reconveyance, it could be a big deal. What are the others?
Okay. And all three of those signatures.
Okay, wait a minute. We're going to run out of time today, and what you're talking to me about are the kind of things it would take a 4-hour show to go through all of that information. If you will call back tomorrow night, I'll have more time to go through it, and email me those documents, and I'll look them over first. The full reconveyance is interesting because when these guys transfer the note or deed of trust to another entity, there are some things they are supposed to do, and one of them is file a release of lien in the record, and then the the person they transfer to files their own lien. And sometimes they get that wrong, where they release one lien in the form of a full reconveyance, and the other guy doesn't get his lien filed in. So I'd like to look at that, but we don't have time to go through all of that, especially where you'd have to read the whole document for me to know what it is, and we don't have time for that.
I understand that, but you're Randy, you're Mr. Kelton, your radio show, right?
Yes.
Open My Eyes with Alex Jones. And listen here, do you have a fax number, or what is the email?
I have an email, randy@ruleoflawradio.com. Send those to me. I can look the documents over, and then I'll have a good idea what you're talking about and can move things along a lot quicker.
I really appreciate it, Mr.
If you don't listen to this show all the time, most of my listeners has heard all this information several times. Because, I go over this over and over. So I don't want everybody sitting here listening to stuff that they've heard a whole bunch of times and doesn't go to issues. So if you'll call in tomorrow night, I will be up to speed and I can move things along a lot more quickly and get you some good answers.
I'll let you go. Let me tell you, what time is it? I'm Pacific time. What time does the show come on?
6 o'clock your time.
Right now, I'm Pacific time, and it's, I don't know, I can't even see.
It's 8, okay, we start 8 o'clock Central. We started an hour ago. It's 9:30 here now.
All right.
So if you're Pacific, it should be 6 o'clock Pacific.
What I'm going to do is I'm going to fax, maybe I'll just fax the whole thing, man. I don't know. That might be too much, right? 52.
No, don't fax me the whole thing. Call me tomorrow. I'll tell you. Call me at 512-430-4140.
512-430-4140. Thank you very much, Mr. Kelton. I appreciate your interview. Thank you. Have a great night. I'll continue to listen to your show. It's great. Bye-bye.
Okay, bye-bye. Okay, now we're going to go to Dave in Texas.
Randy,
hello, Dave.
How are you, sir?
I am good.
Good. Hey, I had a little mishap in Tarrant County last Thursday morning. I went into a JP hearing for a forcible detainer action, and when I got there, the judge said the case was already heard. I was about 2-3 minutes late. And this gentleman knows me. I've been in there a few different times. So I sat there and waited for a case to be over with. The JP dismissed the court. And I said, Mr. Hayes, can I have a word with you? He says, as long as it's not about the case. So I informed him that he was a defendant in a federal lawsuit. Well, he didn't take that too kindly. And he gave me 72 hours in the Tarrant County jail for contempt of court. And I was wondering, is there any recourse that I could take for that?
Of course there is. He did. He was not. You weren't in court at that time.
That's the way I saw that.
That he did not have that authority. And there is some question about why did you go to him and tell him that he was a defendant in a federal lawsuit?
Well, that particular case he said he ruled on, he shouldn't even heard that case because that case involved him.
Okay, well, then that was about the case then. But even so, that didn't go to contempt. Did you spend 72 hours in jail?
I spent a little bit over 72 hours in jail.
Okay, file criminally against the judge and file suit against him for false imprisonment.
And same thing with his constable who arrested me?
No. Constable acted in good faith reliance on competent authority.
Okay, so strictly on the judge.
Yeah, now if you had have said to the constable, hold on here, Mr. Constable, you need to arrest that judge instead, then he would have been put on notice. But if you didn't argue the arrest with the constable and give him reason to question the validity of the request, then you won't have a case against the constable. And, while I like to beat him up for doing things wrong, the constable is not in a position to argue with, refuse to do what the judge says if there's no cause.
Okay.
So I would, and besides, you'll weaken your complaint against the judge if you go after the constable. And in this case, the judge is the guy you want. Which JP is this?
Precinct 7, Matt Hayes.
Good. Then we need to get a judicial conduct complaint against him, and criminal complaints with the DA. And we're about to go to break. When we come back on the other side, I will explain to you how to handle the criminal complaints with the DA, because I've already talked to him, and you might get to sneak right past them straight to the grand jury.
Correct.
This is Randy Kelton, Deborah Stevens, Eddie Craig, Rule of Law Radio. Our call-in number, 512-646-1984. We'll be right back on the other side.
Underage drinkers aren't the only ones who should worry about getting carded these days. I'm Dr. Catherine Albrecht, and I'll be back in a moment to tell you why handing over your driver's license could have a whole new meaning.
Your search engine is watching you, recording all your searches and creating a massive database of your personal information. That's creepy, but it doesn't have to be that way. Startpage.com is the world's most private search engine. Startpage doesn't store your IP address, make a record of your searches, or use tracking cookies, and they're third-party certified. If you don't like Big Brother spying on you, start over with Startpage. Great search results and total privacy. Startpage.com, the world's most private search engine.
Would you share your address with perfect strangers? Probably not, but if you hand your driver's license to a store clerk, you may be sharing even more. Licenses contain a goldmine of digital information like height, weight, address, and birth date. Stores can scan this into their databases to create marketing profiles. Overweight? You might get targeted advertising for the latest diet pill, all because you were carded. Here's a tip to make your next ID request less invasive. Place removable white tape over the magnetic strip and barcodes on your driver's license. The clerk will be able to make a visual verification, but won't be able to download your data. I'm Dr. Catherine Albrecht. More news and information at CatherineAlbrecht.com.
Here at Zombie Killer Ammo and Guns, we believe that the Second Amendment guarantees our rights as citizens to be able to defend ourselves and our loved ones. We also believe that the right to carry weapons comes with the responsibility of being safe and smart about guns. So if you're going to be in the Corpus Christi area, give us a call at 361-704-6103. Ask for Chris or Portia and mention this radio ad for a 10% discount. We can ship ammo, parts, and accessories. Like us on Facebook at Zombie Killers, LLC.
At hempusa.org, we offer chemical-free products to people around the world, detoxifying, self-healing, while rebuilding the immune system. We urge our listeners to please consider our largest-selling product, Micro Plant Powder. Our Micro Plant Powder is rich in iodine, probiotics, zinc, and silica to help rebuild the immune system and to create a healthy stomach flora. Micro Plant Powder is excellent for daily intake and is perfect to add to your storage shelter. We urge our listeners to please visit us at hempusa.org. And remember, all of our products are chemical-free and healthy to eat. We constantly strive to give you the best service, highest quality, and rapid shipping anywhere. And we offer free shipping on orders over $95 in the U.S. Please visit us at hempusa.org or call 908-691-2608. That's 908-691-2608. See what our powders, seeds, and oil can do for you at hempusa.org.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
Yeah, and who you want to chip? Who you take me for? Free Tole? Who you want chip? Me no free Tole. You can't chip me. All I'm saying, don't let them chip you in the morning, chip you in the evening, put a chip in your body. And anyway you go computer ready, you can't hide me say from nobody. When me say, chip in your mom, chip in your daddy, chip in your grandpa and the grandme, chip in me, chip in your baby, chip in your family, whole family, chip in your dog and the cat around we, chip Chipping at the beef and you still go eat tea. Chipping at the fish, them all in the sea. Chipping at the shark and the whale around me. You know see mankind, they aren't chip crazy. Them the kind of thing, man, they want to read me. Social security, them go tell me. Number with them give me, them repeat up, you see. I'm chip you in the morning, chip you in the evening, chip you all at dinner time. Experiment on mankind. But man, you know say them lie. Well, you don't want no chip, man, you have your body. Freedom or something, man, you fight for it.
Okay, we are back. Randy Kelton, Deborah Stevens, Rule of Law Radio, and we're talking to Dave in Texas. Okay, Dave, this judge is pretty arrogant, apparently.
He is.
I'd take a good shot at him. Did you take a good look at the paperwork filed in the county recorder's office?
When you say the paperwork, which paperwork?
All the documents filed concerning your eviction issue. Is this a foreclosure eviction or is this a eviction like from a rental property?
No, it's a foreclosure, forceful detainer action.
Okay, did you look at the paperwork in the county record to see if the trustee who did the foreclosure had authority to do that foreclosure?
No, Randy, the trustee did not have the authority to do so.
So sue the judge for lack of subject matter jurisdiction.
Okay.
That'll make him happy. How did you get to the fact that the trustee did not have subject matter jurisdiction?
Okay. All right. So then when you're saying the trustee...
No, wait a minute. That was the question. You said the trustee did not have jurisdiction. How did you get there?
Well, all they had was the trustee's deed they brought into the hearing like they normally do.
Okay, hold on.
Authority is not filed in public records.
So what is not filed?
The agency agreement or the authority to go ahead.
Okay, hold on. You're using the wrong terms.
Okay.
Is there a deed of trust in the county record?
Yes, there is.
Who is the lender on the deed of trust?
Oh, boy, I don't have that right out in front of me.
Okay. These are the things you need to know. You need to know if the lender named on the deed of trust is the same entity that appointed the substitute trustee.
No,
if he's not, then is MERS included in the deed of trust?
Yes.
Then the deed of trust is void as a matter of Texas law.
Okay.
Because under the transfer of property rights, the document purports to transfer legal title to the trustee as it should in order to create a trust. In the next paragraph, together with all improvements or whatever, all additions to this property, this goes to including any improvements to the property in the collateral. So if you add a room on the house and they foreclose, you can't take the room off. Or if you add an outbuilding, you have to leave the outbuilding. Well, when they put MERS in, they added a sentence in there that says you understand that MERS is not the beneficiary, even though when it first names MERS, it calls them a beneficiary, but MERS merely holds legal title.
Okay.
Problem is, in order for this to be a trust, the trustee would have to hold legal title. So since after claiming to give legal title to the trustee, they now give it to MERS, the trustee has no legal title to sell. So that in Texas law under Texas Business Commerce Code 23001, I believe that's what it is, 22, maybe 21 or 22 of the Texas Business and Commerce Code. It specifically forbids a lender from forcing the borrower to transfer property to the lender. Strictly forbidden. And that's exactly what the deed of trust does if it has MERS included in it.
And it does.
And that renders it in violation of state law and void for ab initio from the beginning. That means that the bona fide holder of the note may have a claim against you personally, but they have no claim against the property. Beyond that, if there was no appointment of or assignment of the note and deed of trust to a third party by the lender, then the third party can't appoint a substitute trustee. And this is what normally happens. You'll use a mortgage company that was set up as a front.
Correct.
They never owned the note to start with.
Correct.
The special purpose vehicle is the one that supplied the money to purchase the deed of trust. So when the deal was made, the note actually belonged to the special purpose vehicle, not the mortgage company.
Correct.
But they didn't want to put that in the record because that would show that the mortgage company did not secure funds to purchase the warranty deed from its Federal Reserve account, but got those funds from somewhere else and used their position to hide the real source of the funds. This is what happened to Washington Mutual. That's why they got put out of business, because they were getting their funds from the Colombian and Mexican drug cartels.
Oh, boy.
And it looked like they were pulling these funds from their Federal Reserve account when, in fact, they were getting them from the special purpose vehicle, who got them from the drug pushers, and used this as the largest money laundering scheme in the history of mankind. Their problem was they were competing with they were using the guys who were competing with the CIA for drug sales in the U.S., and CIA got PO'd about it, put Washington Mutual out of business. They're now investigating Bank of America, HSBC, and Deutsche Bank for exactly the same thing, and Wells Fargo.
Okay. Well, this was definitely a countrywide to Bank of America loan, but then all of a sudden it went into a trust.
Okay. What is the date on the trust? At the end of the name of the trust, there will be a date, a year.
And Randy, I don't have that in front of me, but I want to say what's
Hold on. I'll explain why I said that, and then you can look. The trust, these kinds of trusts, these pass-through trusts are only open for inclusion for 3 months, and then they close.
Okay.
So you look at the date of the note.
Okay.
If the date of the note is similar to the date of the trust, then you look at the date the note was supposedly put into the trust. I have one I just worked on yesterday, 2006 note, 2006 trust, 2008 assignment. Not.
Right, exactly. They're closed up.
Right, that had to put it in 2006. And in this case, it was National City Mortgage, who went bankrupt in 2008. And so what I'm betting is that if you look at the bankruptcy, you will not find this note listed as an asset because they sold it back in 2006.
Okay.
They didn't notice that they sold it in 2006 because then you would see who they sold it to, and that would give an indication that some hanky-panky was going on. So they pretended like they got their money out of the Federal Reserve and held the note. If they showed that they sold it, they'd had to pay back the Federal Reserve, and the Federal Reserve would notice that they weren't getting any checks from this company, and they're selling all this property. Where's all that money coming from and going back to? So they didn't do it to hide the fact that they were laundering the money. This is the argument that we're making.
Okay.
And the lawyer's going to say you can't prove it up. Who cares? Let them try to disprove it.
Well, then back to the judge, Randy. What would be my steps where would I take my complaint to? The DA?
Take it. Okay. We're running out of time, so I'll go quickly. Put it in an envelope.
Okay.
And go down to find out when the grand jury's meeting. Go down to the grand jury room, and there will be a bailiff standing in front of the door, and tell the bailiff your name, give this to the foreman of the grand jury, and then turn around and leave.
Oh, that's simple.
That's simple.
Randy, I greatly appreciate it, sir.
Okay. If you got more questions, call back tomorrow night. This is Randy Kelton, Deborah Stevens, Doug. I'm sorry I didn't get to you. We kind of got a stack of calls and ran out of time. And Mike, call back tomorrow. We'll get to you then. Thank you for listening, and good night.
Thank you very much.
We have one.
It is so enlightening to listen to 90.1 FM, but finding things on the internet isn't so easy, and neither is finding like-minded people to share it with.
Oh, well, I guess you haven't heard of Brave New Books then.
Brave New Books?
Yes, Brave New Books has all the books and DVDs you're looking for by authors like Alex Jones, Ron Paul, and G. Edward Griffin. They even stock Interfood, Berkey products, and Calvin soaps.
There's no way a place like that exists.
Go check it out for yourself. It's downtown at 1904 Guadalupe Street, just south of UT.
By UT, there's never anywhere to park down there.
Actually, they now offer a free hour of parking for paying customers at the 500 MLK parking facility, just behind the bookstore.
It does exist. But when are they open?
Monday through Saturday, 11 a.m. to 9 p.m. and 1 to 6 p.m. on Sundays. So give them a call at 512-480-2503 or check out their events page at bravenewbookstore.com.
Are you the plaintiff or defendant in a lawsuit? Win your case without an attorney with Jurisdictionary, the affordable, easy-to-understand 4-CD course that will show you how in 24 hours, step by step. If you have a lawyer, know what your lawyer should be doing. If you don't have a lawyer, know what you should do for yourself. Thousands have won with our step-by-step course, and now you can too. Jurisdictionary was created by a licensed attorney with 22 years of case-winning experience. Even if you're not in a lawsuit, you can learn what everyone should understand about the principles and practices that control our American courts. You'll receive our audio classroom, video seminar, tutorials, forms for civil cases, pro se tactics, and much more. Please visit ruleoflawradio.com and click on the banner or call toll-free 866-LAW-EASY.
Okay, I'm brain dead. I admit it. I do this all the time. I've got a clock here, and when I move down so I can see my callers, the actual time rolls up just off the top of the screen. And I do this all the time. You guys should get used to me saying when the show's over when it's really not. Sorry about that, guys. And I haven't even been drinking any rum. I think it's his peppermint tea doing this to me. Okay. Now we're going to go to Doug in Texas. Hello, Doug.
Hi, Randy. Yeah, could I talk to Deborah?
Yeah, I'm here. What's up?
Yeah. Hey, Deborah, I'm a little bit more like you when it comes to this. I don't think Ken Anderson needs to resign and get his, $10,000 a month pension paid and do this and that and the other. He's a sociopath. He lived for 25 years when he knew that he put a good man in prison and a guy that had just lost his wife. I mean, how cruel, how inhumane, just like I said, sociopathic or psychopathic or whatever you want to call it. That guy needs to lose everything that he's attained by his illegal conduct and spend the rest of his life as wrong, but he needs to be behind bars. You agree with that?
I absolutely agree with that. I mean, it's horrible what he did to Mr. Morton. I mean, I just cannot fathom, what could be going through someone's mind like Ken Anderson when he does something like that. And you know that Morton wasn't the only person that he's done that to. That's just the only one where he got caught. And it's just completely heartless, no conscience, no thought whatsoever that it's wrong that he put this innocent man in jail for murder, knowing that he didn't commit the crime, committing crimes, withholding all this exculpatory evidence, et cetera, just so he can have another notch on his belt, so move up in his career. I mean, that is beyond heartless. Okay, that is vicious. It's evil. And it's just, I just can't even fathom. This is why we tell people who seem to be so naive about what our public servants are doing, is that you cannot judge the world based on your own moral compass. Okay, you can't just write these kinds of things off as conspiracy nonsense just because, well, how could anyone ever do something like that? Well, the reason people think like that is because they would never do anything like that. Well, that doesn't mean that somebody else isn't capable of doing it. All right, and so that's what I always tell people. You have to step back. And you have to, when you're examining these things or contemplating these things, and not look at the situation through your own personal moral compass, and then come to this conclusion based on emotion, pure emotion, that, well, the facts can't be facts. It must be a lie. The facts must be lies, because there's no way that anyone could ever do something like that. Okay, I mean that is a mental illness that people have to get over. So that's my concept about it, my thoughts on it.
Deborah, you're absolutely right. And this guy has shown that he is such a sociopath, completely lacks empathy, and he can go to sleep every night and buy him a new bass boat and do this, that, and the other, and enjoy life and get along, just thinking, I've killed another guy, basically.
I know.
I've destroyed this man's life, but I'm going to enjoy my life and this and that and other. And then now we're contemplating making him retire early, where he'll get $10,000 a month, taxpayer money to continue that. He just won't have the same title. He'll just be a retiree.
Yeah, it's pretty ridiculous.
Lehmburg or whatever.
Mm-hmm.
To me, that's unconscionable.
Absolutely. All right. Well, Doug, listen, we've only got about 6 minutes left, and we got two other callers on the line.
Thanks for taking me.
Okay, sure thing, Doug. All right, we are going now to Mike in Texas. Mike, we have to go quickly because there's one other caller after you. What is your question tonight?
Oh, I'll just kind of follow on to the statute of limitations discussion you had earlier.
Okay, go ahead.
Let's see. I understand there's, what is it, Wallace v. Cato, or Cato v. Wallace? I'm not sure. I think that was a Supreme Court decision. It's kind of sad that Wallace was convicted of murder. He was in Chicago in 1994. He was in prison until 2002. And within a year, he filed a malicious prosecution case against Cato, and it went all the way up to the Supreme Court. The Supreme Court said his statute of limitations told while he was in prison. He was released on DNA evidence. So think about that.
So, Randy, what is your comment on that? That's basically what we were talking about earlier.
Yeah, I remember that case.
Okay, so then this statute of limitations defense may not necessarily fly in Ken Anderson's case.
Well, no, that's what they said, that this guy's out of luck.
Oh, they said the guy's out of luck. They ruled against him. Oh, that's too bad.
So you can't pursue this because statute of limitations ran, even though you were in prison and couldn't effectively fight the issue, that this is what the law said, and they weren't going to change it.
Oh, boy.
So they said, basically, you're screwed.
Oh, that's too bad.
And so we need just an amendment to the statute to say that if you commit a crime and you're not prosecuted, but the effect of the crime, the harm is still being exacted, then the statute of limitations does not start to toll until the harm ceases. And every day this guy was in prison, he was harmed another time.
Absolutely.
So that would be a way to fix that part. But the Supreme Court was right. That provision wasn't in there, so they couldn't add that provision to it. In this case, we may have felt like that would have been a nice thing to do, but we don't want the Supreme Court writing law for us.
No, of course not.
If you remember a few years back up here in Texas, there was a mall that wanted to expand into a neighborhood, and these people didn't want to sell. And the city took it under, the state took it under eminent domain, and they appealed to the Supreme Court, and the Supreme Court ruled against them. They didn't rule against them because their claim was unjust. They ruled against them because they said, this is a state matter, and we don't have any business interfering in a state matter. And we got a lot of people railing about how unjust that was. And I looked at it as a great ruling. As the Supreme Court said, if you want this change, you'll have to change your state law. We don't have any business interfering there. So in that regard, good decision. But that was a message to us that we need to move for legislation to extend that statute of limitations. That will act to affect some changes. But then again, the technology that they're using is relatively new. The DNA tests, at the time this occurred, they didn't have the DNA test. So the DNA alone may have the effect we need, because if the prosecutor pulls this shenanigan, then down the road it can be discovered. It'll be discovered more quickly now, so a lot of that will go away. I'm kind of thinking while I'm talking here, how do we address this issue of prosecutors withholding evidence?
Well, Randy, isn't there already a law in the books that say that if there's exculpatory evidence, the prosecutor has to submit that to a grand jury?
Yeah, there is, and it's official oppression if he doesn't.
That's what I thought.
But the problem is, if the prosecutor committed official oppression against a person, got him put in prison for 3 years, by the time he gets out, it's too late to try to discover the error. When you've got lawyers, defense counsel, that their only purpose is to make sure you don't have a matter for appeal, then you wind up in a police state where you have a 99.6% conviction rate, just like we have. So we need to get our defense counsels re-empowered, and that's part of what bar grievance is for. That's why we need to grieve them every time they move and sue them at every opportunity, and give the defense counsel plausible deniability. They'll have to do their job to keep us from suing them and filing criminal charges against them and bar grievances. Then maybe we'll actually get some justice. How does that sound to you, Mike?
Hold on, I had to mute him because he had a lot of background noise. Thanks for calling in, Mike. Good points. All right, folks, this has been our Thursday, April 25th, 2013 edition of Rule of Law.
It really is the end of the show.
And this time it really is the end of the show. And we will be back tomorrow night for our Friday 4-hour info marathon. So folks out there, Will wanted to talk about DUIs. Folks call back in about mortgage issues or whatever other issues you may have. Randy, any last comments?
No, just thank you all for listening, and we'll look forward to our good show tomorrow night. We've been having some great shows and great calls, and I appreciate all of you. Thank you, and good night.
Thank you. Good night, and God bless.
Bibles for America is offering absolutely free a unique study Bible called the New Testament Recovery Version. The New Testament Recovery Version has over 9,000 footnotes that explain what the Bible says, verse by verse, helping you to know God and to know the meaning of life. Order your free copy today from Bibles for America. Call us toll-free at 888-551-0102 or visit us online at bfa.org. This translation is highly accurate, and it comes with over 13,000 cross-references, plus charts and maps and an outline for every book of the Bible. This is truly a Bible you can understand. To get your free copy of the New Testament Recovery Version, call us toll-free at 888-551-0102. That's 888-551-0102. Or visit us online at bfa.org.
You're listening to the Logos Radio Network at logosradionetwork.com.